that is. Welcome, everyone. Glad that you're here on this what's hopefully sunny where you are March day. We have, as those of you who are here in the last couple of minutes know, some announcement from the Law Commission, and I will turn it over to Sandy to share the good news with us about Law Commission.
Yeah, thank you, Justice Duncan. So really good news. You should have received an email from Valerie Sasaki, who's the chair of the Law Commission, but just want to also update here that we have hired Amy Zubko from the Oregon State Bar previously to be the new director of the Oregon Law Commission. We're really, really excited that we were able to get that together. Many of you have...
Recording in progress.
Sorry, somebody came on with a, we good now? Sorry, I was getting a huge amount of echo. So Amy has a ton of experience at the Law Commission. She has worked alongside as liaison from the bar on several projects, including some multi-year projects, so she understands how that works. And just really excited to have her. She's going to be based in Portland and will also be doing a lot of work in Salem. So both with this group, as this bill moves forward and decisions are made about when and how to bring it through the legislature, she'll be an incredibly experienced person to help you all with that process and also just managing the work group moving forward. I'm still going to be helping out with the handoff and making sure that she has all the information and access to all the Zooms and everything like that. So I'm still at UO. I'm not going anywhere. I'll just be not working with the Law Commission formally anymore, but it's been a pleasure. And we're really, really excited that Amy has chose to join us. I sincerely could not have imagined a better candidate, with someone who I think can, and for those of you who are interested in other projects or things you do, I think that this puts the Law Commission in a really strong place moving forward to have someone with that type of legislative experience and connections in Salem to work with, and with the legal community with their experience with the bar, to really help shepherd important work through the Law Commission moving forward. So it's really good news. I'm really excited.
Thanks, Sandy, and we are grateful for your continued service and support of our work group. We know that this has been something that's really just you doing on top of all of your other work, which is probably already 2 jobs. So we appreciate your providing us the continuity and support that you have, and we're glad we'll have you one more meeting before you leave us to help us with the transition. And we look forward to working with Amy and all of the experience that she'll bring to our group, which we will definitely benefit from as we present our bill in the next legislative session. So thank you.
You're very welcome. Thank you.
We will have a little quick check-in on our small groups. I think Justice Kidd was perhaps talking about the work that he and Heather and Jim have been doing. Justice Kidd, would you like to provide a quick update on that?
I would actually like to defer to my colleague Jim because he's the drafter and the mastermind of many things. But we have what I think was a really nice, elegant way to deal with cases that are what was previously called confession or want of an answer. So, okay. Jim, can I hand it to you?
I'm having trouble hearing, but assuming that I have the floor, we met and decided that there should be an opportunity for a defendant to move the justice or municipal court for relief from default, and that if the judge denied that motion, then the defendant could appeal the denial to the circuit court. Perhaps a key here is, though, that if the circuit court the circuit court would have de novo review of the motion, but if the circuit judge determines that the motion should have been granted, then the circuit court would remand the case to the justice court or municipal court for the actual trial. And also the proposal would give the prosecution the opportunity to appeal from an order granting such a motion. But
And the upper
scope of
courts,
review would be de novo with a remand to the Justice or Municipal Court if the Circuit Court would have reversed.
and the upper courts review is really whether that motion should have been granted. It's not a brand new trial. It's really a more focused review.
Heather, I see your hand.
Thank you, Justice Duncan and Jim and Justice Kidd. So I wanted to add a couple of things. One, that the proposal that we coalesced around would address some current issues in the system. You know, one, that the grounds for moving to set aside default judgment were limited before, and also that there wasn't a mechanism previously for having a record to show what happened at the Justice or Municipal Court if it was an oral motion. And you know, so and also that it would require de novo review at the Circuit Court. So recognizing that that we're dealing with courts that aren't courts of record, and so there might be some logistical issues. But I also wanted to add that, and I don't think any of our memos have circulated on this yet, that this was like a resolution that we all agreed on, but it wasn't the one that I thought was the best option. There's a memo, it's my minority report, as Jim calls it, which is attached to the other documents which will circulate with Jim's really well drafted proposal that discusses what I understand to be the current system, which would allow appeals of default judgments without a motion to set aside. And then also some of the policy considerations for why that might be a good system to keep in place. And so I'm not going to like enumerate all of those arguments for you now, but I just wanted to highlight for you that I think it's worth consideration before deciding to adopt this proposal, even though this was a very thoughtful proposal.
Thank you. And I haven't seen any of the memos yet. I understand you guys have just coming in, have you been working together? And that's been great, and you've been circulating these materials, and then I expect that you would route them through Krista, and then we would share them with the group. But we do appreciate that some of the work that we're doing, we've been able to say there's this interesting subgroup, and they've been handling it without the need to involve all of us until you kind of coalesce around something, or can say here's the two different views. And then I saw Jordan's hand up, and then Melissa's. Jordan.
Thank you, Justice. I just wanted to make sure, when I think Jim says that the only question on appeal is whether or not the default should have been granted. If the circuit court judge decides that the default should not have been granted, then my assumption is that it gets kicked back down to the municipal court then to redo things without or continue things without the default. But I just wanted to make sure that my assumption was correct.
Yes, intent is that if the circuit court reverses, the case would be remanded to the Justice or Municipal Court for a trial, as if no default had ever been taken.
Okay. I don't like to assume that I know the answer to things, so just double checking. Thank you.
Melissa.
Thank you. So that was sort of my question as well. But just to further follow up on that, I heard Ms. Merrick said that the court would have de novo review. And to me, that means being able to do a trial on the violation at circuit. So I just want to make sure that it is limited to, you know, that should have been granted, send it back. That would be my proposal, at least. And then the other thing is there going to be something specific with regard to these that indicates that specifically that a defendant must exhaust that relief or judgment before appealing it to circuit court.
Well, the wording that we are looking at right now, let's see if I can find it here. On appeal, the circuit court's de novo review shall be limited to deciding whether relief should be granted under ORS 153.105. And if the circuit court determines that relief should be granted, the circuit court shall remand the case to the justice court for further proceedings. I think that answers the first point you made. I'm not sure I understood your second point.
My second point would be that on appeal, the person must show that they've asked for relief from the lower court in order to appeal it to the circuit court.
Yes, that's the reference to ORS 153.105. That statute would be amended to make clear that the defendant would have the opportunity. Well, I'm sorry. I don't think there's any need to amend that statute, because that statute gives the defendant 1 year to file a motion for relief from default. So that statute is already there. The court rules on, the justice court would rule on it, and then the defendant would appeal from the denial thereof, or the state would have the opportunity to appeal from an order granting the motion.
I think I understand what Melissa is asking, and to add to what Jim was saying, the current proposal would only allow an appeal on the default judgment itself and its validity. If the defendant prevailed, then there'd be a remand for trial. But if they just had a default judgment and they didn't move to set it aside, there wouldn't be the opportunity for an appeal for a de novo trial on the merits. And what I was saying before is that I don't think that should be the case. And I know you and I have had some discussion about this, but that's what the current proposal is.
Before we go to Lindsay, was there any follow-up questions or comments on that issue? Melissa, that those responses address your question?
They do, Your Honor. I just want to make sure that we don't open the floodgates, so to speak, because I could see this getting quite numerous in volume going to circuit court. Thank you.
For other defaults, like default, you request relief from default, and then you appeal the denial of request for relief. Yeah, and I imagine not necessarily that you were going to say anything about that issue, Lindsay, but that would be something OJD would have some thoughts on too. But your hand was up before that, and do you want to go ahead and share what you were thinking?
Yeah, just along the lines of Melissa's first question. So it sounds like this concept would have the circuit court deciding for itself whether or not it would grant the motion for relief from default. And I'm just curious if the court would be permitted to hold hearings, like what would be kind of the scope of the proceedings in the circuit court? Would the circuit court be deciding it based on the motion that was filed in the lower court? So just a couple procedural questions there, and a suggestion that at least the statutory, that the statute just expressly directs exactly what the circuit court is permitted to do upon that decision.
I think that's a good point, and I know we are in the context of getting just a quick update from Jim and Heather, and we are all talking about a proposal and a possible counter proposal that we haven't actually read yet. So I think these comments are really helpful for Jim and Justice Kidd and Heather to make sure, like, as you're finalizing your reports, if you could think about these things and address them, and then we'll have the opportunity for all of us to look at something in writing. So any other, I saw Jordan's hand had been up, but any other things that the group, without necessarily wanting like an answer on, but just say, these are questions that I have just upon hearing your description, and then we can hope that the three of you guys will address them. So Jordan, did you have a comment along those lines? Something you want to make sure that you think about?
No, I think that clears it up. I was just gonna suggest that maybe the answers to some of these will be in the memos when we get to read them.
Okay. Well, I think all of this feedback, even just on the idea of it, is helpful, and hopefully Heather and Justice Kidd and Jim can share with us, address these things in what we get from you to circulate. So thank you for your work on this. And this will provide, this is one of the things that we are doing that will provide clarity about what people can do in this area where our statutes aren't particularly clear. We also, the group knows from our emails, we have, Jim has drafted like a form notice of appeal that we have circulated, and people have provided comments on that. As Krista said in her email, we're not going to take up the notice of appeal today, but we want to draw your attention again to the comments that have been circulated. And if you have any others, please feel free to circulate them to the group. We will take this up. A lot of the issues that we need to still settle are issues that the notice will help frame. So anything else on that, Krista or Jim? Okay. We're going to continue our discussion or review of the working draft, and today we're going to be talking, continuing our conversation about states appeals. And so I'm really glad that we have folks here who can, like we've said at the end of the last meeting, talk about these types of appeals, what the state needs in these types of appeals, which ones make sense to even exist, and what, if there is an appeal, what that appeal looks like. And so we will take these issues bit by bit. And the first one that I'd like the group to talk about are appeals from pretrial orders. And so in Jimmy's memo, the discussion of section 17 begins by talking about pretrial appeals. And the suggestion there, Jimmy, if I may jump in if I'm not describing this correctly, but the idea is there are certain things that statutes allow the state to appeal pre-trial. And the suggestion is that if the state is bringing a pre-trial appeal, bringing an appeal of a pre-trial ruling, does it make sense for the case once it lands in the circuit court for resolution appeal of this pre-trial motion to just stay there? So Jimmy, is that the first question? Anything to add, and do you want to share with the group your thinking on how a resolution of that question?
Sure. So, and I'll sort of preface this by saying the state has probably more interest in this than I do. So anyone who represents the state or government entities in these proceedings probably should correct me if I'm making assumptions that aren't accurate here. But it seems to me that the most efficient way of dealing with this is that once the case goes to the circuit court, it stays in the circuit court to completion. If it's appealed on a motion to suppress, circuit court decides the motion to suppress de novo, and then keeps the case and holds the trial and all of that. And frequently in cases where there's a big motion to suppress, that's the main issue in the case, the trial happens pretty quickly. It could be a bench trial where the parties agree that the circuit court can consider the evidence that was presented at the suppression hearing. It could be a conditional plea, something like along those lines. And I think there are real sort of efficiencies that can happen when the circuit court can just say, okay, I'm denying the motion to suppress. What do you want to do next? As opposed to saying, okay, I'm denying the motion to suppress. Now I'm going to send the case back to the justice court. And it avoids situations that might happen in, for example, cases with multiple motions to suppress or evidentiary motions, where you could have a case that goes back and forth between the Justice Court to the Circuit Court, then back to the Justice Court, then back to the Circuit Court. That doesn't seem efficient at all. So it seems to be the most efficient way of dealing with these is once the state decides, okay, I want the Circuit Court to redetermine this, the Circuit Court should just keep the case and decide everything.
Any thoughts or reactions to that? And then looking particularly at Melissa and Bill and Paul. Yeah, Melissa.
Sorry, it always takes me too long to find the raise hand button, so I figured to just do it the
I
old
thought-
fashioned way. So I would agree with that. I think it's silly to do multiple things twice. It's one of my gripes about not being a court of record here in Eugene. If Judge Gill was here, he'd shake his finger at me. But so I would agree. If we're deciding things already at the circuit court, it does make sense to keep it at circuit court. I can't speak for, if that has any other if there's some sort of reason I shouldn't be saying that. But in terms of efficiency and everything, it just seems to make more sense because we'd have to do the suppression here. I'm just using suppression as the main issue because that's typically what it is. If the suppression is granted at municipal court, go to circuit court to argue that it shouldn't have been granted, and they decide no, it shouldn't have been granted, go back to do trial, they get de novo, let's say they're found guilty by a jury, they get de novo appeal to circuit court, we have the same argument all over again, and probably trial all over again. So I would agree. If we can eliminate certain steps, I think the lower courts were made for efficiency, and if we can't accomplish that at the lower courts, then we should just stick with it at the circuit court. Thank you.
I see Paul. Paul?
Yeah, I would agree with all that. I mean, I don't really, this isn't going to affect me all that much either at DOJ, but one thing that I would suggest thinking about though is if we did have a situation where a state's appeal on a pretrial issue like a motion to suppress just resulted in the case staying in the circuit court, we would need to have a pretty robust cross appeal ability of defendants too. So for instance, say defendant had moved to dismiss on speedy trial grounds and that was denied by the municipal court, and then moved to suppress some evidence and that was granted. If the idea is that a state's appeal on the motion to suppress is going to go to the circuit court and stay in the circuit court, then that would be the only opportunity then for defendants to cross appeal any adverse pretrial rulings that they had received there. And I think the way it works going to like the Court of Appeals right now is there's a little more discretion on the part of the Court of Appeals whether or not to consider those cross appeals in that circumstance.
Are we only proposing this for when the state initiates the appellate process and then allowing for cross appeals at that point? Because it does seem like a more efficient process, but I don't know that it'll be that more efficient for the circuit courts. If it were to be, if there was a lot of these, then it wouldn't be as efficient for them. And the lower courts are designed to be more efficient. So sending it back and letting the lower court correct its own mistake, correct its issue, then resolve the case would be more efficient for the lower courts and for everyone involved. But I just think there'd be some question of what the impact would be to the upper courts and the circuit court as far as efficiency goes. Efficient for the parties, sure, but maybe not for the courts.
And maybe something we would think about would be how often the state is, and this would just be, right now, we're only talking about the pre-trial appeals, not the post-trial appeals by the state. And so maybe the question is, how frequently does the state initiate these pretrial appeals And that will be something to consider because it would affect the additional work if all of the cases where the state does bring a pretrial appeal stay with the circuit court. I don't know, do you have a sense of that? I know we don't have across the state representation, yeah, I guess it would be how often the state would be appealing things like motions to dismiss pretrial or motions to suppress pretrial.
And I don't know that I have the answer to that for our county. Other counties may have different impact, may take that issue up more often. I don't think that the DA's office in Clackamas County is involved in that very often at all.
Okay.
I can't remember an instance where we've done that. But that, you know, I assume it could happen, but I don't know that, I don't have that number for you. I'd like to hear, I want to hear from more from counties that utilize that process more often.
Okay. Jim, I saw your hand, and then Jordan. Jim?
Yes, I wanted to bring to the work group's attention that in municipal court, if a defendant raises an issue of the constitutionality of the ordinance that the defendant has been charged with violating, and the municipal court determines that the ordinance is unconstitutional, the city can take an immediate appeal to the circuit court. Now, my understanding is that if the circuit court reverses, it sends the case back to the municipal court for a new trial. So that is one instance where you do have this interlocutory pretrial appeal with a remand to the municipal court. Now, I don't know how often those things happen, perhaps very seldom or perhaps even never. And I don't know how, if those things happen, how efficient or not efficient they are. But I was thinking that whatever process we decide is the best one, they probably should be the same for both for both types of courts.
I think that makes sense, and I'm glad you flagged that issue, that though we already do have a provision regarding those types of challenges. And I think this might relate to something that is in Jimmy's memo, which is if we know certain challenges like motions to suppress are kind of case dispositive, then they are likely to go from the local court to the circuit court and then possibly even to your court of appeals. So there's certain types of things which are going to be on the trajectory to the appellate court of appeals anyhow. And I imagine challenges to the constitutionality of a city's charter or a city's ordinance might fall into that category. So those might be cases that are going to the court of appeals anyhow. And if we were to say, bring your interlocutory challenge to the local court, then we'll send it back. We'll have the proceedings in the local court, then you'll have to appeal to the circuit court in order to get the court of appeals to be able to appeal your case. You know, if the cases you're talking about, Jim, are likely to end up in the court of appeals, maybe it is more efficient to leave them in the circuit court once they hit that court. I saw Jordan's hand up.
I pushed the lower hand button instead of the unmute button. One day I'll figure out virtual meetings. So two thoughts. One, it seems like to me it'd be simpler to leave things in the circuit court rather than bouncing them back and forth. I can just imagine scenarios where parties will be confused as to what court they're in, especially if they're pro se parties. And it just seems like a logistical nightmare for the circuit court to open and close cases a bunch of different times. I haven't done that side of things since they brought in Odyssey, but I remember when we were still doing paper files at the circuit court when I was clerking way back when, that would have been ridiculous to open a whole bunch of paper file cases and then store them if they were bouncing around, because I assume they would each get a different case number. But maybe that's more in the weeds than I need to be. My other thought on this is for cases that aren't pro se, we'll probably want to think about what happens to the defense attorney on the case. Often when cases are appealed to circuit court, the case is reassigned from the municipal court defender to the circuit court defender's office. And so if it's going up partway through the case, I don't know that that makes sense, but if it's going up, or at least not the same way it does if it's going up at the end of the case, but we'll probably just want to make sure that there's some continuity of counsel through the life of the case.
That makes sense. Lindsay.
Jordan, just on that court-appointed counsel issue, I do think that generally they are different attorneys because the circuit court will, need to get an application for court-appointed counsel and do an appointment for the circuit court representation. And I think, in my understanding at least, is that in some jurisdictions, the attorneys that do some of the justice and municipal court appeals might also, or cases might also take court-appointed cases in the circuit court, but that is not always the rule across the state. So I think a lot of times these would be different attorneys. On what I wanted to raise before is I wonder if these matters are going to stay in the circuit court, if on a pretrial appeal from the state. I wonder to address the issue of the cross appeal from the defendant, if the court should just do a de novo trial, an entire proceeding in the circuit court. Because if we're at the motion to suppress stage and the court is already reconsidering that in the first instance, I mean, maybe the case could just start over like we already have, the process already is after a judgment and of conviction. So just a thought on that.
That's an interesting thought. Any reactions from the group that if we're taking a pretrial appeal, just start over, kind of treat it like a transfer request by the state? Jimmy and Paul, I see your hands. Jimmy?
Sure, I think that makes sense to me. I mean, in misdemeanor cases, there's usually not a whole lot of pretrial motion practice, and so I'm not sure it's really going to create that much more work. And if the parties don't really care about some earlier motion that was filed, they can just either withdraw it or stipulate to a particular disposition or something along those lines. And I think there could also be situations where, for example, the only reason that a particular motion to suppress is coming up is because of some ruling on some earlier motion. And you could have kind of awkward situations where the circuit court is now being asked to decide something on the assumption of this earlier motion that's baked in, where it's maybe not even clear to the circuit court what the full resolution of that earlier motion was because it doesn't have a transcript. So to me, that probably makes the most sense, but it would avoid the problem of working out what the cross appeal statute should look like. But I'd be interested in other people's thoughts.
Mm-hmm. Paul? And Paul, and then Tony, and then Jim?
Yeah, I mean, I think that largely makes sense. Just some concerns or things that come to my mind are, Lindsay, under what you're suggesting, would it then be that if the state appeals a pretrial or prosecution appeals a pretrial order, the circuit court, is it reviewing that de novo, or is it reviewing what the municipal court did for errors of law? And if that's, I guess where my concern comes in is, if we're just transferring the whole case up to the circuit court, then, and let's say there were multiple pretrial motions, some that went in favor of the defendant, some that went in favor of the prosecution, I wouldn't want to see a situation where some of those pretrial rulings were reviewed under one standard of review and others were reviewed under a different standard of review. I mean, but if the answer is, hey, the state disagrees with a pretrial ruling, we just want to move this to circuit court and start everything all over again. That makes sense to me. Otherwise, I do think we have to consider the impact of cross appeals.
And I saw Tony and Jim.
Thanks, Justice. Years ago when we did these appeals, I was in the municipal court. My experience is mostly Eugene and Springfield municipal courts. So a lot of this is kind of, I don't know what happens in the other courts, but years ago, the defense counsel would stick with the case if it went up on appeal. It went to the circuit court on appeal. Pretty convenient, easier for the client, everybody, the relationships were established. They don't do that now. And what something Jordan mentioned does, one of my reactions is, I don't like the idea of the state being able, the city in this case, in the cases I know about, to take the case, effectively just remove it to the circuit court. Maybe they don't like that the municipal court judges have been too easy, quote unquote, on some issues. And then everything stays in the circuit court. I have a little trouble with that. But then Jordan said, continuity of counsel. Once they get to circuit court, they will get court-appointed counsel, assuming it's indigent defendants, the people I represented. I think I like the idea that they continue with the same counsel. It would be tough on a lot of the clients I'm thinking of to have to go back and forth and figure out who their lawyers were. But I also think is a lot of the issues we talk about here, I suspect, again, with my limited experience in the couple of courts I've worked in, I suspect that these issues aren't going to be they're not going to come up very often. I don't think there's going to be a lot of these appeals like this. I haven't seen a lot of them. And, effectively what would happen if a case went to the circuit court on an appeal, often they get resolved because there's a ruling in the circuit court, and then the defense and prosecution get together and resolve it. So I think generally what we talk about here may be at the outer edge of what really happens, what happens most often. So I don't like the idea of kind of recreating the whole system just to account for kind of outlying cases, if I'm right, and I could be completely wrong about that. But I do think that if they go to the circuit court and stay there, I would like it to stay de novo. I kind of like that concept. In other words, everything stays there and start all over again, and the judge gets a good picture of what the whole thing looks like. Okay. Those are my thoughts on it. Thank you.
Yeah. And then Jim, and then Justice Kim.
Yes, thank you. One of the reasons I suggested including the opportunity for pretrial appeals from justice and municipal courts is that there was a right to such appeals, at least with respect to misdemeanors that are prosecuted in circuit court. And I thought, well, why shouldn't the systems be the same? As we have worked through this issue, though, it has become apparent to me that the fact that the circuit court has de novo review, I think really changes a lot. And I am beginning to think that maybe the system that we have now, which is basically there's no right to appeal from the pretrial orders, works best, and that we should not have appeals from such orders because the trials in the justice and municipal court happen pretty quickly, not particularly formal, and there's a prompt. There is the opportunity for prompt appeal to the circuit court and to get de novo review. So I'm thinking that maybe we are overcomplicating the system. That the system seems to be working now. I haven't heard that one of the big criticisms of justice and municipal courts is the lack of opportunity for appeals from pretrial orders. So maybe we should leave well enough alone because the opportunity for de novo review in the circuit court on all issues seems to be working.
Okay, I'm gonna see if Justin or Jimmy are gonna respond to that point, but I think the pretrial appeals that we're concerned about are the state's pretrial appeals, because there's some things that the state can't appeal after the judgment. So if it's not, if the state can't appeal it before the case gets tried and completed, it never gets to challenge it. And so I thought you had added the pretrial stuff, just for the state, but I could be wrong about that. I don't know if Jimmy or Justice Kidd have a response to this issue about whether we even need the pretrial appeals or any of the state representatives.
So I would just say, because I misstated this in my memo, and that may be part of the source of confusion here. Under current law, under ORS 157020, the state can appeal from pretrial orders, at least suppression orders and orders dismissing the indictment or charging instrument under current law. The bill adds a bunch of additional categories, but those are almost all post-trial orders. It slightly expands some of the categories of pretrial orders that can be appealed, but currently under current law, the state does have the right to appeal, for example, the denial of a motion to suppress.
Yeah, and I assume that we want to retain that. But the state would be interested in retaining. Justice Kidd.
Yeah, just on the most brief thing in response to my colleague Tony, you were worried that the state would have the ability to sort of opt out of local court. In misdemeanors, at least under current law, the defendant also has the ability to opt out if they choose, right? So I'm not very worried about that. At least in my court, misdemeanors, like we just don't do them, right? We're a violations court. So I agree that what the group has said, a lot of what we're talking about here is very rare, like given the actual majority of the work that we do here.
Okay, any other thoughts on what a pretrial appeal, which is the state's appeal, really would look like? Any other thoughts on it? Yes.
Well, I'm sorry. I
It's
just
okay, Tony,
jumped.
go ahead.
Thank you, Melissa. In response to Justice Kidd, yeah, I mean, we did our cases rather formally in municipal court. We'd have full jury trials and so forth. And yeah, I understand what you're saying. The defense can move the case, I think, before it starts to the circuit court. But traditionally, this government, the city, has not been able to do that. So I would not let that. Would be to me a kind of a change that might have other repercussions. It's a long history of not doing it that way. So that's kind of my thought. I just respond to you. Thank you.
Thank you, Melissa.
Yes, and Justice Duncan, just because you had asked the question earlier about, how often does this happen? I'll say for the time that I've been here, which has been 5 years now, none of us have taken an interlocutory appeal. And Tony has served as a defense attorney for Eugene Municipal Court much longer than I've been here. So he may be able to give a little bit more context too.
So that
about the rarity.
Yeah, so that may inform whether it's much of a problem to just say if the state is bringing a pretrial appeal, then maybe the whole thing moves, and that's may not be a tremendous workload issue for the circuit courts. So, okay, I think that gives us ideas on that type of pretrial state's appeal. We have about 15 minutes left for today's meeting. There's one issue that I think we can hopefully address pretty quickly. Jimmy, this is the issue about appeals from local court orders granting it would be a defendant a new trial. And the question is, should the state, like it does in the circuit court context, the state can appeal a grant of a new trial to the Court of Appeals. So the question is, should we have a parallel provision from the local courts? And you had some thoughts on that.
Sure. So the question is basically, assuming the state takes such an appeal, what should it be able to get? And then depending on what the answer to that question is the game worth the candle? So one thing it could get is, for example, a whole new trial, but that would give it the same thing that it's already getting in the justice court and it presumably doesn't want. Another possibility is it could get some kind of a de novo determination of whether a new trial should have been granted. But that's a very awkward thing for the circuit court to do, because in the frankly very rare situation where a motion for new trial is granted, it probably had something to do with something that went wrong at the original trial, which the circuit court judge wasn't there for and doesn't have a record of. So that option gives the state something useful, but seems to put the circuit court in a situation where it might struggle to yield a sensible result. There could be some kind of non-de novo review of a grant of a motion for new trial, but it's not really clear what that would look like because, again, the circuit court wouldn't have any knowledge of what happened in the original trial. So those are the three kind of unappetizing options I see. And I'd be much more interested in hearing from somebody who represents the state or municipality in terms of, and the answer might be this happens so rarely that it just doesn't, we don't really care that much about it. But what would you want to see happen in such a case, and how can we make that work, given the confines of the fact we're dealing with a court that's not a court of record?
Well, being from the state, I would say that I don't know that it happens that often. But I don't know, since we don't handle violations, that goes to our justice court. Our municipalities do handle misdemeanors, but then they also, those city attorneys then handle those as appeals. I don't know how often that would happen. One of the concepts we were talking about earlier about a de novo review would be efficiency. And so if there were an appeal from, or a motion for a new trial, then it seems like it would be, if it was de novo under those same premises for efficiencies in the other circumstances, then you would want to do the same thing and just get it done. I don't know how often that happens, and I'd like to hear from somebody that maybe deals with it in that way.
I'm not offering anything, mostly because I have never seen it happen. I think most of the time people just appeal it de novo, and that's where
Okay.
we're at. I don't think it happens at all. I don't know, Tony, have you ever filed for a motion for a new trial?
Never in the municipal court. No, and it's just a rare thing because you got the clients that we represent. People don't have as much time as we lawyers do to litigate these things. The defendants are just they don't want to be there. They don't want to spend a lot of time with it. They don't understand it. They just as soon get it finished if they're going to go to a jury trial. I mean, as somebody noted in one of these memos that came through, I think it might have been Lindsay, I'm not sure, but the number of folks that appeal and then don't show up is pretty high. So there's kind of an attention span here that goes on. I think motions for new trial would just be an exercise for the lawyers to enjoy and not so much for the defendant. So I think it's pretty rare that it would happen, and I haven't done it.
So if I can, before just recap it, the defendants aren't really filing these motions for new trial because perhaps there's no point because you can just get a new trial by filing a notice of appeal in the circuit court. The state, and we're still talking about states' appeals, the question is, in the rare event that the defendant files a motion for new trial and it's granted, does the state need to be able to appeal that grant? And it sounds like it's unlikely that that's going to happen, but even if the state were to appeal the grant of a new trial, then and win, it would come maybe back down to the local court, and then the defendant could still appeal de novo anyhow. So Jimmy, your suggestion is let's not have states appeals from grants of motions for new trial. Is that right? In the memo?
I think that's one possibility. I mean, the other thing that occurs to me is if a defendant gets a new trial in, say, a justice court, and they have a second trial in the justice court, they're still able to appeal at the end of that if they're convicted a second time. So it would give them a third trial. I guess there could be a value to the state in saying, okay, if you want a new trial, let's just move it to the circuit court and we'll be done with it after that one trial. Now that I think about that, I think that's a reasonable thing for the state to want, but I don't know if the state actually does want it. So those would be two viable possibilities that don't ask the circuit court to do anything weird. It's just stuff it already does.
And just across the top of my screen, I have Justice Kidd, Paul, Lindsay, and then Melissa on this topic. And if you had something else not on this topic, we'll just go to the next person. Justice Kidd.
Just super briefly, I mean, it seems like it's a thing that doesn't normally happen. If the concern is that there's no record, it's such a weird, rare thing to happen. You could put in the statute that the justice would have to put findings of fact and conclusions of law, right? Just so there would be a record. I don't know if we want to do that, but that is a way to solve the record problem that would not be overwhelming because it doesn't happen very often.
Paul?
And echoing that it doesn't happen very often, it seems like even if there was no state's appeal or prosecution appeal written into the statute, if the municipal court really committed a manifest prejudicial error in granting a new trial, it seems like mandamus is always available in those rare circumstances. I can imagine a situation where the court should not have granted a new trial and the prosecution, for whatever reason, can't retry the case. Maybe witnesses are gone or whatnot. I don't know. I mean, given the rarity that it happens, I feel like mandamus is always a good backstop for the manifest injustices.
And since one of the requirements for mandamus is that you don't have another remedy, if we have this other remedy of appealing the new trial, then that makes your mandamus case harder. So mandamus might be more available if we don't have the state's appeal. Maybe. Lindsay and then Melissa, and then we'll wrap up.
I can see the both arguments of getting rid of the state's appeal in this context or allowing some kind of appeal. And I would just echo what I think, Jimmy, you were saying, which is maybe it is okay to just have a de novo trial in the circuit court. And that's what the state would be getting out of the appeal if they decide to take it, is the trial being in the circuit court rather than the same court that it was in before. So I wonder if that's kind of the simplest if we're going to keep these types of appeals.
So it would be the state appeals the grant of a new trial. And basically then it would be, okay, you get your new trial, but we're going to have it in the circuit court. So it would almost be like if the state would have this option of a transfer at the new trial stage. Okay. And then Melissa?
Yes, thank you. So I was just reflecting a little bit. Maybe it's just because I haven't been in trial for a bit here, but I was thinking about just defense's request for a mistrial, and I'm sorry if I'm rambling, but defense's request for a mistrial that gets granted. And because we're not a court of record, we can't really flesh out the reason for the mistrial. I can't think of a situation where we would file an interlocutory appeal to have it reviewed by the circuit court, and then just do the de novo trial. I think we would have to do it. It would seem silly to go and say, hey, yeah, it would seem silly to go there, say this shouldn't have been granted, and then there's no record, so it's kind of odd. And then just to have them say, okay, well, if that is what happened, if that is the reason the mistrial was granted, and there was a new trial to be held, I don't know, I can't even think of a reason that would ever happen. But it would seem silly to go back and just do the trial all over again, which would be ultimately, I don't know, it just seems odd. But if we were to have the interlocutory appeal, I agree with Lindsay's comments. I think we should just have the new trial at circuit. It just doesn't make sense. I'm trying to think about this boots on the ground, and I'm just not, it's not making a whole lot of sense. But and again, I can't see a situation where we would do an interlocutory appeal on this, but in the event that we do, I would agree. I think it should just stay at circuit court. Thank you.
Okay. That's, all of that's very helpful, I think. And we're closing in for 1 o'clock. So we will end our discussions there so people can